Happy Monday morning. I am Carol Williams with Williams Immigration, and we are back for another Monday morning edition of Beyond the Soundbite, where we talk about all things U.S. immigration. So let's dive right in. The first thing I want to talk about is becoming a U.S. citizen. And we know that we need to file an application to actually become a U.S. citizen for most folks, unless you have a natural claim to U.S. citizenship via birth, which maybe you didn't know about. But most people, if they don't have a claim to U.S. citizenship already, they need to file an application for U.S. citizenship. As part of that application, there is an interview at your local USCIS office, and there is a civics test, which you can think of as U.S. history. So during the previous White House administration, they had made some changes to that civics/history test, and it was a very short-lived sort of change. But now USCIS has actually changed its policy manual. They have removed all references to what was then the 2020 version of the naturalization civics/history test. And the only current version, the only version that USCIS is now using, is back to the 2008 version. So if you are applying for U.S. citizenship, you can go on their website, you can search citizenship, you can search civics test. They have PDFs of all of the possible questions for the civics/history portion of your interview, and they're all right there on the USCIS website. And so this new guidance, this sort of the deletion of the quote unquote new civics test, the 2020 version. This new guidance took effect to remove that on May 4 of last month, but comments are due, if you have any issues with them removing this, by June 5th. So those comments are due today. So the next thing I want to talk to y'all about is comprehensive immigration reform. We hear about this often. Many people are saying that we need to do something with our immigration system, that there are many things about it that need to be tweaked, changed, or completely overhauled, depending on where you sit on that spectrum. Well, Representatives Escobar out of Texas and Salazar out of Florida have come together and introduced what they are calling the Dignity Act of 2023. And this is comprehensive immigration reform. It's comprehensive immigration reform bill that, in their view, they have touched on border security and infrastructure, a legal pathway for individuals that are here to obtain status, pathways for individuals to obtain citizenship if they are here undocumented, and new pathways for asylum seekers for them to obtain asylum, as well as touches on unaccompanied minors. So I went to Representative Escobar's website as part of when I was preparing to talk to you all about this today. And I want to read you what is on Representative Escobar's website. And it says, quote, "This bill gives dignity to the border agents who need support, the job creators who need employees, the American people who need secure borders, and those who currently live in the shadows," end quote. So what I'm not going to do this morning is kind of go through the entire immigration reform bill with you piece by piece, in part because it's quite comprehensive, but as this winds its way through Congress, this will change. And so I don't want people getting confused about what is currently being proposed versus what is actual current law. So it is quite a large piece of legislation. It is aiming to really overhaul and reform the immigration system in the United States. It was introduced by a Democrat and a Republican, so we have folks talking across the aisle in Congress. And so I will keep you updated on this comprehensive immigration reform bill as it winds its way through Congress. So it was just introduced, so it will undoubtedly go through many, many iterations before we are looking at something that is a final. The next thing I want to talk to y'all about is Florida Senate Bill 264. It is currently being challenged via litigation. And what it does is, effective July 1, 2023, when this bill goes into effect, it will limit and restrict individuals who can own land in the state of Florida. And it's ownership by what this particular bill is calling foreign principals, from what the bill calls foreign countries of concern. So those countries of concern listed out in Florida Senate Bill 264 are China, Venezuela, Syria, Russia, Iran, North Korea, and Cuba. So individuals from those countries, as of July 1 of this year, will be severely restricted in terms of how they can own land in the state of Florida. So this bill is already being challenged. There has been a lawsuit filed by 4 Chinese citizens who filed in district court on the grounds that this particular bill is discriminatory in their ability to own and purchase real property in the state of Florida. And they are basing the discrimination on race, ethnicity, alienage, and national origin. So I will keep you in the loop in terms of what happens with this legislation. There may be more legislation that comes to get this particular bill, Florida Senate Bill 264, changed, tweaked, completely eradicated. We don't know yet. But that is starting to wind its way through the court system. So I will keep you in the loop on that in our Monday morning chats. The next thing I wanted to talk about is administrative processing. So administrative processing is what happens when an application is being processed with the Department of State. So it's being processed by one of the many consulates overseas. And that consulate feels that they need more time to do more security checks on that particular application. So that application then falls into what we call administrative processing. Many of my colleagues and I call administrative processing a black hole. It is a black hole because the Department of State gives us zero information. They don't tell us what they are potentially looking for. They don't issue us a request for additional evidence so that we can't address their concerns. They call it security concerns, and they really just kind of go radio silent on us. So now they have said that they have they've really sort of given us an update, basically saying that they have started to use new technology, which is helping them resolve their administrative processing and resolve the background checks in a more timely fashion. So we will see. We will, I guess, sort of see how long it takes them to go through their administrative processing. Some people say they were in administrative processing for a couple of days up to, a couple of months. Some people much longer than that. So there is no one size fits all when it comes for administrative processing timing. But they have told us that they are using new technology that is giving them the opportunity to coordinate with various agencies that they need to be coordinating with and resolving some of these background check issues and getting people out of administrative processing quicker. So we'll see if we see an overall reduction in the timing that we see people in administrative processing. The next thing I want to talk to you all about this morning are the Department of State filing fees. When you are filing overseas for certain visa categories, you absolutely pay a fee directly to Department of State. Initially, they were going to raise those fees, and they are still raising them. So that is not my news. They are still raising them, but they have delayed the onset of these new fees to June 17th of this year, 2023. So June 17th is when these fees will go up. I'm going to give you some of the fees just sort of as a reminder. So the application processing fee for those applications that don't need a petition, they are currently $160. Those will be going up to $185. The application fee for H's, L's, O's, P's, Q's, and R's are non-immigrant visas. Those will go from $190. They will be raised to $205. E1s and E2s, those will go from $205 to $315. Border crossing cards for Mexican citizens age 15 and over, those fees are currently $160. They will go up to $185. There are exchange visitor fees. Those waivers that are $120, those will actually stay at $120. So we're good to go there. There's no changes there. But again, these new fees are they're not going to be implemented until June 17th of this year. So just keep that in mind as you are paying fees and applying and thinking about your timelines. And if that's something that you need help with, feel free to reach out to the office, 954-903-1337, and we can help you with that. And the next thing I want to talk to you about is the medical form. So when you are applying for a green card, you must have a medical report sent to either the consulate or to USCIS if you are in the United States. So there is a new medical form that has been released, and you want to make sure that you are using the new medical form. It was now required as of May 31st of this year. So just a couple of days ago. So just to make sure that if you had your medical taken, prior to May 31st, but you haven't yet submitted it, you want to make sure that the doctor used the new form, because the new form is required as of May 31st. And so you don't want your application to be delayed, because if it's on the wrong version of the form, they will send it back to you, or they will say, we need a new one. So you just want to make sure that you are using the right version of the form. And the forms change. They change sometimes pretty often. They often change coinciding with a change in the law or a change in the policy. So while I don't talk about the nitty-gritty of the forms changing that often, the forms do change. So we want to make sure that we're using the right version of the form. And the last thing I want to talk to y'all about is another national interest waiver tip. As we know, if you guys have been hanging out with me on Monday mornings, the national interest waiver is a green card category. And to qualify for that category, you must show that your proposed endeavor of work, your career choice, what you are doing in your industry has both substantial merit and is of national importance. Second, that you are well positioned to continue to advance in your particular industry and what you are doing. And that on balance, it is beneficial for the United States to waive the usual requirement of having a sponsor, a job offer, and advertising for available and qualified U.S. citizens for your particular position. So the tip that I have for y'all this Monday morning for the National Interest Waiver Green Card is this. If you are in a STEM field, science, technology, engineering, and math, and you want to apply for a National Interest Waiver Green Card, it is so important that you be able to explain your field of endeavor, what you are doing, in very easy to understand terms. If the immigration officer cannot understand and grasp what you are doing, no matter how groundbreaking, no matter how important, they will absolutely 100% deny your application. So I know I work a lot with my clients that are in the STEM field to really have them break down what they are doing so that anyone can understand. And sometimes that takes a little bit of time. That takes maybe a couple of different phone calls, maybe a couple different emails. But it is vitally important to a national interest waiver application in a STEM field. And STEM is science, technology, engineering, and math. That you be able to break it down. I tell my clients often, if you can't break it down for me such that I understand it, I can't then prepare an application such that an immigration officer will understand it. Your immigration officers, and myself included, we are not science people. We may not be hardcore science people. We may not be hardcore math people. So we've really got to be able to sit down and really break down what you do so that anybody can understand it. So that is my tip for a national interest waiver for this week. If you all have any questions about your immigration journey, if you are looking to hire someone who is not a U.S. citizen and you're not quite sure where to go from there, feel free to reach out to my office. If you are an entrepreneur living overseas and you want to expand your business into the U.S. and you're not quite sure what that looks like in terms of your immigration status in the U.S., reach out to our office. We're more than happy to schedule a consultation and get you on your way to hiring that individual or, starting the process to starting your business in the United States. My office can be reached at 954-903-1337. Have a wonderful Monday morning and a